Let's go live button. You know what that means. We got to wait for the tubes to connect themselves. Sometimes things get a little bit clogged in the tubes. As you saw yesterday on the show, we had a little technical difficulty, didn't we? We had some feds in our CPUs or something was going on. But it looks like we're working. We're alive and well. We're connected over on YouTube. Hopefully. There it is. We got Locals is up. Rumble, our friends, is there. Amazing. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about the Supreme Court. That's right, Donald Trump knocking on their door again. We were just here talking about Colorado and, of course, the ballot removal saga brought by Crazy Eyes Griswold and the Democrats out of Colorado. But we're at the Supreme Court again. And this time we're talking about Judge Chutkan and her order that is denying presidential immunity. And so that is on appeal. We're going to go through the full filing, and then I've got some reaction to this. So Trump submitted this brief yesterday, and there's a subcomponent to this. I mean, obviously, we're talking about presidential immunity, but the second story that is joining us is trial before an election, right? That's a major issue on this thing. And so Court of Appeals was really trying to accelerate this. They only gave Trump about a week to actually submit this and file this. Of course, he has. And we're going to see what that does to the entire calculation, because they really want to get Trump tried before the election. We know that everything that has been happening now doesn't count against Trump. In other words, all this time, the case has been stayed. So when the case does land back on Chutkan's desk, it means she's got to give Trump the same amount of time that has elapsed, more or less, so that he can properly prepare his defense. So it's going to really throw a wrench in this whole thing. Of course, SCOTUS could throw a wrench in this whole thing by just granting presidential immunity. But we're going to read through the full state of affairs there today. Then we've got Jen Psaki. We've got reaction from Pelosi. We got Crazy Eyes Griswold is coming up in the House. And we've also got a math exercise from Kyle Cheney. We're going to try to articulate when this case might be coming back down into Chutkan's courtroom for a trial. So that's all coming up in our first segment. We got some reading to do from the Supreme Court brief. And then in our second segment, we're going over to New York, man. And there was a monster bar complaint that was filed. And this came from Elise Stefanik. And it's about 64 pages, man. That's a doozy. You know, sometimes a bar complaint, you get them, you're a lawyer, the client says, I'm upset, it's a page, 2 pages. 64 pages. Whew. And of course, we know that Leticia James, she is a partisan. She's very biased. We have this video of her. We'll refresh our recollection, because she was basically running for office to stop Trump. She said it multiple times, made it the centerpiece of her entire identity and reason for existing. But she's getting a fat bar complaint from Elise Stefanik, and Donald Trump responded to what's happening there in New York. We're awaiting a New York ruling any day now. Some people saying it might come out on Friday. Only time will tell. Who knows what Judge Engoron is doing, maybe playing with his areolas again, but who knows? All right, so we've got a lot to get to today, my friends. This morning, we had a great members-only stream talking about the election. Been talking a lot about election stuff, including Joe Biden's incapacity. We talked about what was happening with him and poked around some other stories. We have a great members-only community. We do streams in the morning. We do streams on Saturday. And we do after parties. As soon as we're done here, we retire to watchingthewatchers.locals.com. And we do our members-only after party and debrief. And we love to see you over there. If you're looking for any PDFs that we're about to go through, because we do have, I think, 3 of them that we'll hit today, they're all available at robertgouveia.com. Navigate over there, grab the PDFs, read the show reports, stop by the shop, grab a shirt, grab a hat, so you can look great while you're watching the show. And then, of course, our newest project is watcherlodge.com. This is our sovereignty and our self-development community. We have an event upcoming with my friend Jason Campbell. He is a Zen wellness master. He's awesome. He's a black belt, a musician. He's a sheriff. He's all sorts of things. He's great. So come check it out. Go to watcherlodge.com. Link is in the description. The event is free. You don't have to become a lodge member or pay anything to come and join us. But be advised, this date might move, right? It's on Friday. And if Fanny's hearing, which is scheduled for Thursday, if it goes into Friday, we'll have to see if our friend Jason can reschedule. But go sign up for it, register nonetheless, so that you know if it does move, watcherlodge.com. And then next week, we also have a food sovereignty workshop that I am super excited about. So bookmark watcherlodge.com. All right, my friends. Now, let's get into it on the day because we got some Supreme Court business to jump into. Donald Trump back at the Supreme Court, this time on a major issue about presidential immunity. Judge Chutkan out of the D.C. January 6th case said Trump as the president has no immunity. He doesn't really get any protections that, Congress people get, that judges get, that police officers get, all this immunity stuff we hear a lot about in our law. Everyone has it except Trump. Well, we'll see what the Supreme Court says about that. I think that they may have a different opinion. But here is the full petition that was submitted by Donald Trump into the Supreme Court. And there's an important subtext to all of this. The idea is Trump is now asking the court to rule on the original petition, right? On the original issue, which is presidential immunity. So he's petitioning them to address the immunity issue, but he's also applying for a stay, right? Meaning that Judge Chutkan wants the January 6th case back on track. And the trial was already scheduled for March 4th. And then if we say, okay, all the days that elapsed between when Trump submitted his appeal, which I believe was December 9th. So all the days from December 9th until it returns back to Chutkan's desk, Trump is going to say, I get that amount of time to prepare my case. So he can say, however many days that is, 9 months, 6 months, 4 months, 85 days, whatever. I need that amount of time. So from March 4th, give me my 90 days, give me my 120 days, then you can reschedule the trial. But of course, we're asking ourselves, well, when is that going to be? Is that going to be July, August, October, right during the middle of the election? Time will tell. But that is a big important issue. We know that really all of this lawfare and election litigation has been brought during the election year or timed right to the election, right? So all the trials would happen right in the middle of the election season. They think that we're so dense we can't see that, but all right. So we're going to read through the petition to the Supreme Court, but this one is also going to the Court of Appeals. Because remember, this came from Chutkan's courtroom up to the D.C. Circuit Court of Appeals. They just affirmed basically her opinion. Took them a long time to do that. And then they handed this back over to her. But Trump could stay this as long as he got his petition in by the deadline, and he did. So they're notifying the Court of Appeals that we got our deadline met. They say, okay, dear clerk, on February 6th, your court, the D.C. Circuit Court of Appeals, you said the following. You posted this in your order. You wrote, the clerk is directed, so the judges told the clerk, is directed to withhold issuance of the mandate through February 12th. That was Trump's deadline. If within that period, Trump notifies us in writing that he's filed an application with the Supreme Court seeking a stay of the mandate, then the clerk is directed to withhold the issuance of the mandate, which gives this back over to Chutkan, pending the Supreme Court final disposition and the application. So as long as Trump tells us that he's appealing in the Supreme Court, the stay will continue in place. And he got it in by that deadline. So they just notify the Court of Appeals. They say, here you go. Here's your written notice. They say, okay, through this letter, Trump hereby notifies you, Court of Appeals, that today he has filed in the U.S. Supreme Court an application for a stay of Chutkan's mandate. A copy of Trump's stay application, along with the file-stamped proof of the filing in the SCOTUS, are attached. You can see we did it. We mean business. Now, accordingly, we request, and they're so upset about this. You see all the headlines flying around these today. Trump delays January 6th. Why does he want to delay? Blah, blah. We request you withhold the issuance of the mandate pending further action by SCOTUS. You said that was your ruling. We've complied with your ruling. Respectfully, your friend, John Sauer. So, boom, paused again. All right, so we'll see what the Supreme Court does. The Supreme Court has asked for Jack Smith to respond expeditiously. So he and his reply brief are due by February 20th, just a short time away from today. But that is now what stays the case in Chutkan's courtroom, and this is Trump's petition. In the Supreme Court of the United States, President Donald Trump appealing Judge Chutkan's order asking for a stay of the original mandate that came back down from the Court of Appeals, delaying the January 6th case, and also asking the Supreme Court to rule on the immunity issue. Here are the questions presented to SCOTUS. 1, whether the doctrine of absolute presidential immunity includes immunity from criminal prosecution for a president's official acts. It's an interesting framing. In other words, those performed within the outer perimeter of his official responsibility. So they're asking for an expansion basically of Nixon. They're saying, okay, well, Nixon versus Fitzgerald, this other U.S. case from 1982, they said that the president does have absolute presidential immunity. Remember, they said that was only for civil cases. And so the president can't be sued for a bunch of civil stuff. And they set this standard, outer perimeter. So they're saying, well, if you've already decided that, how about you just include the criminal code? So, and that's question 1. Number 2 is whether the impeachment judgment clause under the U.S. Constitution and principles of double jeopardy, whether they foreclose the criminal prosecution of a president who has been impeached and acquitted. And this is my favorite argument, by the U.S. Senate for the same and or closely related conduct that underlies the criminal charges. So, zooming out on this again, remember, Trump has already been impeached for insurrection. Okay, that was the whole basis. They put that in their impeachment document. Insurrection, and he did all this crap. Now, the Senate acquitted him on that. Nancy Pelosi's House of Representatives impeached him, so they got that house. But when he was tried in the Senate, he was acquitted. No one convicted him of that, which is curious because the Constitution has a very, very nicely articulated concept in there that once you are impeached and convicted, then we know that this is not a political problem. The Senate is the cooling saucer of American governance. If it goes over to the Senate and you get 2/3 of the Senate to say that this person, this president, did something criminal, that means it's not political. That means that it's not just a partisan hack job by Nancy Pelosi, because even the Republicans are in on it, and you have a supermajority of 2/3 of the people. So then you know it's not political. They've been impeached and convicted. Now it's fair game. Then you get to open the floodgates, charge them with whatever you want, related to that conduct, obviously. But that did not happen here. Trump was acquitted for insurrection. They charged him with a pseudo-insurrection anyways, not actually even the insurrection charge. In fact, they didn't even charge him with sedition. So here is what the rest of the petition looks like. We're going to fast forward right in to the good stuff, past the table of contents, table of authorities, and so on, until we get right to the introduction. Donald Trump says to the Supreme Court, the application here in this case is deja vu all over again. We've already been here. 2 months ago, after Judge Chutkan denied Trump's claim of presidential immunity, Jack Smith filed a petition to you, Supreme Court, asking this court to undertake an extraordinary departure from ordinary process and decide a vital and historic question of presidential immunity based on a hyper-accelerated basis. So remember, Chutkan granted Trump's appeal. That put a stay. Now, denied his immunity, right? But he appealed that. She issued a stay. Jack Smith freaked out. Went to the Court of Appeals, says, could you please expedite this? Went to the Supreme Court, said, can you hear our case? They said, no, get out of here. Go back through the Court of Appeals. Now, this court correctly chose to follow standard judicial process and declined Jack Smith's request to leapfrog the Court of Appeals. Now, Jack Smith, at his urging, he's arguing to a panel of the D.C. Circuit they have in an extraordinarily fast manner. They issued a decision on President Trump's claims of immunity, and they ordered the mandate returned to Chutkan, and they wanted Trump to go back to his criminal trial in just 4 business days, right? Trump, you have like 4 days to respond, unless this court intervenes. And they're saying, that's why we're here. We hope you do. Now, the Supreme Court, Your Honors, they say, this court should stay Judge Chutkan and D.C. Circuit's mandate to forestall, once again, an unprecedented and unacceptable departure from the ordinary appellate procedures and allow Trump's claim of immunity to be decided in the ordinary course of justice. So stop speeding things up. Here are the reasons, Supreme Court. The reasons to do this are compelling. First, Trump's claim that presidents have absolute immunity from criminal prosecution. It is a novel, a complex, and a momentous question that warrants very careful consideration on appeal. They're trying to ram this through because they're concerned about an election, but this is an actual important issue that's going to, have impact on the country for the foreseeable future because it defines the scope and the power of the presidency. Now, the panel opinion below that came from the Court of Appeals, it concludes that Trump and that presidential immunity from prosecution, they say that it does not exist at all, right? It was a wild opinion. The president has no immunity. If you are prosecuted for official acts, you do not have immunity, period. That's what those, judges out of D.C. said. This is a stunning breach of precedent, they say, and it's a stunning breach of historical norms. In 234 years of American history, no president was ever prosecuted for his official acts. Ever. Not once. Do you think another president in American history may have done something that was questionable, borderline, in the outer perimeter of what's official conduct? Could they be? They say presidents must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. Their decisions are the most politically controversial of any official, and they draw the most national attention and the political ire, making the president an easily identifiable target for politically motivated prosecutions. They say if the prosecution of a president is upheld, such prosecutions are going to recur. They're going to become increasingly common. They're going to usher in destructive cycles of recrimination. We're living through one right now, the first one. Criminal prosecution, with its greater stigma and even more severe penalties, it imposes a far greater personal vulnerability on the president than any civil penalty. Obvious, right? If they gave the president civil immunity, seems like criminal might be the next. The threat, they say, of future criminal prosecution by a politically opposed administration will overshadow every future president and their official acts, especially their most controversial decisions. Now, the president's political opponents, they're going to seek to influence and control the other president's decisions via extortion or blackmail. There's going to be this looming threat, whether it's explicit or implicit, of an indictment in the future. If you do anything, then you could be indicted for acts that don't warrant any such prosecution. Now, this threat will hang like a millstone around every future president's neck, distorting a president's decision-making, undermining their independence, and clouding their ability to do their duties. Without immunity from criminal prosecution, the presidency as we know it is going to cease to exist. Because all you need is Fani Willis to charge. That's all. Just a couple prosecute. Alvin Bragg can do it. You get Jack Smith, who's not even legally appointed, right? He comes and does it. And they time them all, four of them. They time them all with an election, right? It was all orchestrated clearly. So, they can point to that. Let's see if they do. They say President Trump's application easily satisfies this court's traditional factors for granting a stay. So just allow this case to continue to be paused while all this is being addressed. And they also want, maybe they're going to have en banc review. So maybe they're going to take this back to the D.C. Court of Appeals for a full panel en banc review. Remember, it was just 3 judges who decided the last opinion. So here, they want a big stay, right? For a long time. So grant the stay. Then we're going to go back through the Court of Appeals. And then review on certiorari by this court. So it sounds like they're going to do like 2 things. So it depends how the court, splices this. The court could say, okay, stay granted, go appeal again and get an en banc review in the DC Court of Appeals, and then that would really extend this out, right? In terms of timing, like that would be, Jack Smith would lose his bananas because that would be a whole full court appeal. That would add like another month. So anyways, first they say, this is why you should give us what we want, Supreme Court. First, the likelihood that this court is going to grant certiorari in the future, except this case, is very strong. As the special counsel, Jack Smith, so-called, as he emphatically stated in September, he said this, it is imperative of public importance that this court resolves these claims of immunity. They say President Trump here and his claim, it presents a quintessential example of an important question of federal law that has not been seen and should be settled by this court. And I agree with this point wholeheartedly. I think the Supreme Court is not going to want to have the position of the presidency and the standard of immunity settled by these three judges from D.C. Now, second, there is far more than a fair prospect that this court is going to actually reverse the decision. Now, the panel opinion below from D.C., it misapprehends and it contradicts the original understanding of the vesting clause and the separation of powers, as has been interpreted by a long-standing and unbroken chain of historical precedent going all the way back to 1803 in the case of Marbury versus Madison. They say Chief Justice Marshall, back in that case, he thought it was self-evident that Article III courts, like Chutkan's, they cannot sit in judgment over a president's official acts. Otherwise, guess what? They're the president. If the courts can say, well, Mr. President, what you did is legal, or what you did is not legal, then, or what you did is above board or not above board, then that is kind of the judge being the president, and the judge is not the president. They say it can never be examinable by the courts. Now, because the courts, right, and this is Justice Marshall speaking, now because the quote, the courts cannot examine the president's official acts, they cannot enter a criminal judgment against him, or they cannot imprison him on the basis of those official acts. But Chutkan and the Court of Appeals, their judgment seemingly authorizes Chutkan to conduct a criminal trial of Trump based on his official acts before this court even concludes and reviews this momentous question, thus subjecting the presidency to the most intrusive possible examination by the courts and inflicting one of the gravest wounds on the separation of powers in our nation's history, right? And this is what the Supreme Court cares about, okay? And I hear a lot of people, on the left, Judge Lunatic Ludwig and all these people who come out and they say that the court is going to, review Trump's case specifically, just like we heard in the oral arguments about Colorado. Remember that other guy who came in and kind of fell on his face in front of SCOTUS, which is an easy thing to do. It's the Supreme Court after all. We give him a lot of grace on that. But his arguments were just off. He was talking about Trump's case and about how he got due process in Sarah B. Wallace's courtroom. Okay, that's not what we care about. This is not a microcosm. This is going to set policy for the whole country. And every other president's going to have to live with that. And these judges, their opinion is going to be memorialized in the history books of American political jurisprudence until, well, we don't have a country anymore, which might be sooner rather than later, but you get the point. So they want their legacies in the Supreme Court to be much bigger than Trump. Now, third, Trump's team tells SCOTUS, now, absent a stay from this court, if you allow this trial to go back on, Trump is going to be irreparably injured. They say it's axiomatic that President Trump and his claims of immunity is an entitlement not to stand trial at all. Okay, immunity means you don't even get charged. What good is immunity against criminal conviction if you still have to go through the process? It is to literally avoid the burdens of litigation as this case is reviewed. Yet the D.C. Circuit's judgment appears, strangely, to authorize the district court to resume the criminal trial proceedings immediately. What? And they're going to allow Chutkan to conduct a criminal trial while his claim is pending before this court. Now, so that's why we need to stay. Now, and there is a strong indication that the district court, Chutkan, is going to do this. She's going to take this case and run with it. Now, in addition, Trump is also the leading candidate for president in 2024, in case you didn't know. Joe Biden can't talk. Conducting a months-long criminal trial of Trump at the height of the election season, which is what they plan for, will radically disrupt Trump's ability to campaign against Joe, which appears to be the whole point of this entire persistent demand for expediting this case. Saying the D.C. Circuit's order, it thus, Court of Appeals, threatens to immediately and irreparable injury to Donald Trump's First Amendment rights as well as tens of millions of American voters who are entitled to hear Trump's campaign message as they decide how to cast their ballots in November. Now, this court, they say should stay the Court of Appeals mandate pending resolution of this petition. We also request that you stay the underlying case while we resolve this and we petition for an en banc consideration in the Court of Appeals before filing, if necessary, his petition for certiorari in this court. So we've got a lot going on. So Trump really does want this to go back down to the Court of Appeals. I wasn't sure about that up earlier here, but he is confirming that, saying as long as we have a stay, we're going to drag this thing out as long as possible, which of course is the right move. They say because that's how a normal case goes, right? Getting a case like this, it's wild, right? When you say to the left, why did you guys wait until 2023 to file your charges, knowing that the trials would all be scheduled in 2024? Why'd you do that? They say, well, it's a real serious case. This took a lot of work. We had to investigate a lot of things, Rob. And this took a lot of effort on our part. It's a serious charge and a serious blah, 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 that garbage. You've heard of that. So then why doesn't Donald Trump get the same benefit? Okay, if it took them from January 7th until August of 2023 to indict him, then why doesn't Trump get that same amount of time to prepare his case? Why does he get like 9 months? Because it's rigged. That's why. So here is the statement. They say, all right, listen. President Trump, as we know, was indicted on August 1st. 4 counts. Ridiculous charges, including 2 counts alleging violation of 1512c2 for his alleged conduct. Now, all the conduct that was alleged, it occurred between November 2020 and January 2021. Trump was impeached for much of the same conduct that was charged in this indictment. And guess what? He was acquitted back on February 13, 2023. So there's no new conduct here. Okay. All of the conduct alleged in the indictment happened between November and January. Then they tried him for this in the Senate, meaning there's no new conduct alleged in the trial in the Senate. And he was acquitted. So the indictment charges Trump with 5 types of conduct. Okay. All of the 5 types of conduct in the indictment, those are all literal official acts of the president. They're charging him with crimes for that. They're arguing Trump should be immune. First, it says that Trump, using official channels of communications, made tweets. Wow. He made public statements about matters of federal concern. Is a president allowed to do that? He said that the election was tainted, sure as heck was, by fraud and irregularities, which is true, obviously. We all know that everywhere. Now, and the president is apparently not allowed to say that. Okay, that is the indictment. He got indicted for saying the election was fraudulent. Public statements, first charge. Second, the indictment says he talked to the Attorney General and the DOJ about the fraud, which of course is the president's job. He says, I think I've got evidence of fraud. Should I talk to my Department of Justice? Maybe they can look into this. Good idea. No, sorry, Trump, illegal. He oversaw the DOJ because, he was the president. What was the communication that was so illegal? He urged the acting attorney general and the acting deputy attorney general to actually investigate the fraud. And there are allegations that they talked about this in the Oval Office about whether to replace this guy or not. Which again, those are all, you might disagree with those decisions. You might say, well, maybe that's a little unorthodox or whatever your opinion is. But that's within his power to do that. He is allowed to make those changes. Not illegal. That's a presidential power. Third, the indictment also alleges that Trump communicated with state officials, urging them to exercise, not break the law, to exercise their official responsibilities, saying that the election was rigged. That illegal? To call senators? They're in government. Call state officials? They're in government. And fourth, the indictment also alleges that Trump communicated with Pence. Is he not allowed to talk to Pence? Urging them to use their official duties to not let elections be rigged. Okay, it's your official duty as a state person, as a vice, president, someone in a position of power to make sure that our election is not tainted by fraud and irregularities. You got to talk to those people. They charge that with a crime. And fifth, they said that they organized alternate slates of electors to ensure that they were doing their job, right? These alternate slates of electors were designed to validate the authorities that they said that Pence had. All of this, you might disagree that it's a smart thing to do. You might say, well, it's not my strategy. I wouldn't follow that approach. But it's within the outer bounds of the president's duties. He's allowed to do all of those things. Wasn't asking anybody to do anything illegal, and the indictment itself mentions that. Right? It mentions the conduct that they just articulated. So they say, all right, well, based on all that, I mean, that's like presidential conduct. He's being charged with a crime for doing the things he's been elected to do. But they say, all right, so with that indictment here, Trump filed a motion to dismiss multiple grounds. As relevant here in this matter, Trump said the indictment must be dismissed because it's charging him for his official acts as president, and thus barred by absolute immunity. It's his official acts, he can't be charged. They say the indictment also must be dismissed because he was acquitted in the Senate for the same conduct, and that's double jeopardy. Now, on December 7th, that's when Judge Chutkan ruled against him. Said, sorry, Trump, immunity denied. Now, they held that immunity, Chutkan said presidential immunity from criminal prosecution for official acts. Like, they're not even talking about non-official acts. They say it does not exist in any circumstance. I can't imagine that stands, honestly. That's crazy talk. It held that a federal prosecutor may bring criminal charges against a former president based on conduct for which he was also acquitted during an impeachment proceeding, even though the impeachment judgment clause articulates differently. So the president is just fair game for any prosecution. Now, Chutkan, when she was in this, she did not assess whether Trump's actions fell within the outer perimeter of his official responsibility. She didn't care, or were official acts on any basis. She neglected that. Doesn't matter if it's official act or not. No immunity, period. Instead, she held that immunity from prosecution does not exist at all. Everyone else has it, right? Legislators have it, judges have it, police officers have it, but the president doesn't. Only he can be prosecuted. Now, for the same reason, Chutkan did not conduct fact-finding on this subject or give Trump an opportunity to even present any facts regarding the official nature of his conduct prior to a potential trial. Could have scheduled it for an evidentiary hearing. Didn't do that. Just denied. No immunity. Now, President Trump timely appealed to the Court of Appeals. And Judge Chutkan, after they had to fight her over this, she stayed the proceedings in the district court pending the outcome of the appeal. And remember, Jack Smith just kept filing motions. He's like, well, we're just going to keep this going. Like, we're going to have trial whenever we want it to. And Trump had to, give him the old backhand, proverbial. On December 11th, Jack Smith filed a petition to the Supreme Court. He said, please help us. We're going to lose our pre-election trial. And they filed a petition to expedite this. This court denied. However, Jack Smith was able to convince a D.C. Circuit Court of Appeals to hear this appeal on an extremely accelerated basis. They gave President Trump just 10 days to draft and file his opening brief, and only 3 days to file his reply brief, and they set the case for oral argument 1 week later on January 9th. Rapid fire. Boom, boom, boom. Because they got to hand this back over to Chutkan so she can get the trial back on track. In his brief to the D.C. Circuit, Trump said, if the court affirms this in any respect, we ask that the court stay the issuance of the mandate. But the special counsel said, no, we're not staying anything. They requested the court stay the mandate for 5 days because of the, quote, imperative public importance of a prompt resolution on this case. Now, on February 6th, the D.C. Circuit Court of Appeals panel, they issued a pathetic per curiam opinion because they're so weak they couldn't even put their names on it. Weak. Ruling against Trump's immunity claims. And they provided an analysis that overlooks and mischaracterizes many of Trump's major arguments. And we read through that here. If you missed that one, it was a wild opinion. They were logically inconsistent within their own document. It was crazy. They were actually even saying, like, Trump is not even making this claim. And then in the next paragraph, they're like, oh, and then in Trump's prior filing, he made this exact claim. And you're like, you just said he didn't. And he just did. You just said he did. So what are you doing? So on the same day, the circuit entered a judgment directing the clerk to issue the mandate back down to Chutkan within 4 business days. Like they're just passing, like they're just friends, right? Hot potato, here, it's back to you. Go fast. But if Trump didn't file an impeachment, petition. So the D.C. Circuit Court judgment, it directs the clerk to issue the mandate. Trump has notified everybody. Of course, we're here. Now, this order that they submitted that was accelerating all of this, it departs from DC's ordinary procedures. They say the rules say that the court will ordinarily ask for a 7-day mandate withhold. But on February 12th, Trump filed this application, and here we are. So they're telling SCOTUS now, Trump's team says, stay the mandate pending resolution of this case, because we are going to be going back down to the Court of Appeals and asking for a full panel opinion en banc. Now, here's the argument. They say the standards for granting a stay are pretty low. There must be reasonable probability that 4 members of the court would consider the issue meritorious to grant certiorari. There must be a significant possibility of reversal, and there must be a likelihood that irreparable harm will result. Now here, each of these factors warrants a stay. Here's why. They say, first, there's a reasonable probability that you're going to grant this case. You're going to grant petition. 2 issues. 1, does Trump have absolute immunity? And 2, can Trump be impeached and acquitted and still prosecuted again? Saying the court is likely going to want to answer these questions. These are pretty important questions. Certiorari is warranted when there is an important question of federal law that should be settled by this court. Bingo, that's us. This case raises important questions of federal law, obviously. As Jack Smith advised this court, it is fundamental. It goes to the heart of our democracy. Is a president absolutely immune from federal prosecution? Great question. I say yes. They say Trump's claim of absolute immunity is a quintessential example of an important law. We agree. If you don't address this, it is going to be a big problem. The public importance, Supreme Court, and they're all going to agree with this, of presidential immunity cannot be overstated. As we explained above, an absence of criminal immunity for official acts, it threatens the very ability of the presidency to function at all. I would say even exist, because they're going to be prosecuted for everything, theoretically. Any decision by the president on a politically controversial question would face the threat of indictment by the opposing party after a change of administration. As soon as the president's gone, they get charged. Like, don't tell me they're just going to say, we only did it once because Trump and January 6th. Like, yeah, right. All presidential decisions would be exposed to undue wrongful pressure from opposing parties because he's going to be under threat of indictment when he leaves office. Now, the denial of immunity, it threatens every future president with both attempts of de facto extortion, like do this or I'll prosecute you, and blackmail, and years of post-office trauma at the hands of their political opponents. Now, the threat of prosecution will also become a political cudgel that is used to influence the most sensitive and the most important presidential decisions with a menace of personal vulnerability when they leave the White House. The DC judges, their categorical denial of immunity would forever undermine the independence, the authority, and the decisiveness of the presidency. And the more consequential the decision, like a president's like, should I do this or press this button? Yes or no? The more likely the political opponents are going to use the threat of wrongful criminal prosecution to bully and extort the president, gravely weakening the independence of the presidency and thus our country as a whole. Cycles of recrimination are inevitable, thrusting the most sensitive and vital presidential decisions in the nation's future into a context that will be under threat of prosecution. All this directly contradicts the founders' careful design, as explained below. And it's like obvious that it does. It's in the impeachment judgment clause. They say the DC Circuit's decision also warrants review, Supreme Court, because it decided important federal questions in a way that conflicts with this court. Now, there's also a serious possibility that you're going to reverse Judge Chutkan. Here, the DC Circuit's opinion mischaracterizes this court's case law, like they got it wrong because they're not bright. And it commits a series of fundamental errors. A full accounting of these errors must await a merits briefing. We have to actually talk about those on the facts. But President Trump is good. We're going to get into it further. But let me highlight a couple of these things here for us now. First, this is why the Court of Appeals was so dead wrong, they say. The panel's analysis of Marbury versus Madison, one of the most, if not the most important cases in American law, is wrong. They don't understand it. And that's okay. A lot of people don't understand it. but those people shouldn't be, federal judges. But all right. The executive vesting clause. They say the executive vesting clause provides that the executive power shall be vested in a president of the United States of America, right? And then this is the person, right? The president. So when you start seeing them talk about like office of the presidency and all that, it doesn't say the executive power shall be vested in an office of the presidency. You see that word in there? No, you don't. It's not in there. And this is what we talk about when it is the so in other words, if NARA, right, says that, they're in control or something, it's like, no, that's not true. Unless you got a constitutional amendment, you can't subordinate the president's executive power to someone else. It's in the president, not the office of the president, the president. And when you try to do weird things with that, it's like dividing by zero. Now, for another branch to arrogate the executive power to itself, like if a judge has that or if a Congress has that, and dictate how the president must exercise that authority, that's a violation of separation of powers. It's not your power. It's the president's power. The Constitution says so. Now, as a direct corollary, the clause provides that the judicial branch can also not sit in judgment over the president's acts, and that any attempt to do so violates the separation of powers. Because if a judge can say, sorry, Mr. President, you should have done this, the judge is the president. If the National Archives can say, sorry, Mr. President, you have the right to opinion clause power, you have the right to your opinions in writing under the Constitution, but NARA and Congress said you have to declassify all this crap with a bunch of... No! Unless that was an amendment that modifies this, the answer is no. Okay? It is the executive power of the president. Now, they keep trying to water that down, but it's not right. In Marbury versus Madison, Justice Marshall described this doctrine as foundational and self-evident. Now, by the Constitution of the United States, they said, the president is invested with certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his own conscience. Okay, we elected the person. They're not governed by the judiciary or Congress. Now, when it comes to the president's official acts, they said, whatever opinion may be entertained of the manner in which the executive discretion may be used, still there exists and can exist no power to control that discretion. And this is a big deal. Like when they did this, like, wow, okay, the court is not gobbling up power for itself, right? This was like a deferential opinion and it really set the tone for the whole country. It was incredible. So wow, we can't, okay, this is what established judicial review. So nothing can be more perfectly clear than that, okay? The president's discretionary acts are only politically examinable. That's how the Constitution works. So questions which are, by the Constitution and laws, submitted to the executive can never be made in this court, okay? And therefore, the president's official acts, therefore, can never be examinable by the courts. We don't get to decide as a judge or as Congress what the presidency does. It's separation of powers 101. So consistent with this opinion, they say an unbroken tradition from Marbury to the present holds that Article 3 courts lack the authority to judge a president's official acts. In 1833, this Justice Story, if not one of the most cited judges in America, the most cited judge, he wrote, he said, in the exercise of his political powers, the president is to use his own discretion and is accountable only to his country and to his own conscience. His decision in relation to these powers is subject to no control, and his discretion when exercised is conclusive. That's the power of the presidency. Welcome. Now, in Mississippi, another case, this court, which was citing Marbury, which is building on that, it also held in 1866 that Article 3 courts lack jurisdiction to enter an injunction directly against the president in the exercise of his official duties. So the courts can't impose upon the presidency. They say an attempt on the part of the judicial department to enforce the performance of the presidential duties might be characterized as, quote, an absurd and excessive extravagance. An injunction is, the court ordering you to do something. So can the court order the president to do something via an injunction? No, obviously that's insane. This court has no jurisdiction of a bill to enjoin the president in the performance of his official duties. It's a separation of powers problem. In 1948, they also supported this. This court, the Supreme Court, they're reminding them of their precedent. They wrote that, quote, whatever of this order emanates from the president is not susceptible of review by the judicial department. Wow. You don't get to second guess, saying the judicial branch cannot require the president to exercise executive power in a judicially prescribed fashion. That's crazy because then the judge is the president. That's incompatible with this position. They say it is incompatible with his constitutional position that the president be compelled personally to defend his executive actions before a court. It does not compute. Okay, it's all rooted in the president. If the president becomes subordinated to Congress or to the judiciary, it's all out of whack. Thus, Article 3 courts, they lack jurisdiction to enter an injunction against the president, and no court has ever entered a declaratory judgment against the president. The D.C. Circuit Court of Appeals, they said that the plurality of the opinion concluded that in general, this court has no jurisdiction to stop a president from doing his duties. And a bunch of other stuff is being cited here. Since Mississippi, federal courts have continued this practice without exception, okay, and not a single injunction against the president in his official capacity has ever been sustained. Article 3 courts, they sometimes review the validity of the official acts of subordinate executive officials below the president, right? They do that all the time. You're saying, Rob, don't we see the president get challenged? Yeah, his executives, right? And such review may like they're impeaching Mayorkas, right? And they're going after these subordinates for their failures to act and so on. But such review may reflect indirectly on the lawfulness of the president's own acts or directives. Now, the authority of the courts reviewing the official acts of the subordinate officers, that has never been held to extend to the president himself. There is an unbroken tradition that a president may not be ordered by the courts to perform specific acts. And these two lines of precedent, that the courts, Marbury and the other one, may not sit in judgment over a president's official acts. Okay, they may review the validity of the acts, and they may enjoin subordinate executive officials. Both those originate with Justice Marshall, and they've coexisted in harmony for over 2 centuries until, the Democrats got control of the Justice Department. Now, the distinction they reflect on is not one of mere formalism, all right? This distinction makes all the difference, they wrote. More formally, when a federal court enjoins the conduct of a subordinate executive officer, so in other words, Mayorkas can't cut the fencing, or Mayorkas can cut the fencing, or whatever. It may frustrate the president's will in a specific instance, but it does not seize the very reins of the executive branch by exercising control over the executive department itself. Go after the subordinates, but not the president, because the president is the root power. It is the primary user of the system. Second, more functionally, the president is also entrusted with supervisory and policy responsibilities of utmost discretion. And so when the judiciary enjoins a lower level executive officer, it's less severe intrusion. You're not commandeering the presidency. You're just saying, okay, you can't do that act. Now, accordingly, the vesting clause and the separation of powers, it prevents the courts from judging a president's act. No Article 3 court that understood this until Chutkan came along has jurisdiction to enter an injunction against the president. And no court has even ever ventured to enter a declaratory judgment against the president. Not even just a statement. The authority that's asserted by the lower courts here, which is trying to put a president on trial, enter a criminal judgment against him, and then punish him with imprisonment and other criminal penalties, all for his official acts, it constitutes a core violation of the separation of powers. And so the impeachment judgment clause explicitly presupposes that absent impeachment and conviction, a president cannot be prosecuted for his official acts. We've read that provision of the Constitution many times. They say that out of D.C., the Court of Appeals, they offer a series of arguments. They say, we don't like that Marbury case, but their arguments are not convincing. They say, first, the Court of Appeals judges, they say that Marbury distinguished between two types of official acts, stuff that's discretionary and stuff that's ministerial. Now, it admits that a president's discretionary acts can never be examinable by courts, but it says that the president's duty to comply with the federal law, a duty that no court has ever upheld, right? They say a president has an alleged duty to comply with each and every federal criminal law. And that's a wild statement because federal criminal law, it's written by Congress, right? Congress writes those statutes. So what if Congress writes a statute that criminalizes federal duty, federal conduct of the president? Says you can't challenge elections if you're the president anymore. Well, we have the First Amendment and the president has that right, so he absolutely can. So what if Congress criminalized, like for example, they're charging Trump with 5 crimes for conspiracy and all these things when he was just making sure the election wasn't rigged. So if Congress's statute, which is not a constitutional amendment, okay, Congress just like Joe Biden, okay, was helping involved in, the 1990 crime bills and the 80 crime bills. That is not an amendment. So that can't undermine the presidential power. That's insane. So to say that a president, right, this is again, dividing by zero. If they tell us that Trump has to comply with the federal criminal law, we're asking ourselves, what if there's a conflict there? Now, the ministerial duty of a subordinate official that admits of no discretion. So the characterization from the Court of Appeals of a ministerial duty under Marbury as any duty that is, quote, legal in nature, you can't even square that with Marbury itself. It's like it's inconsistent with the case itself. What renders a duty ministerial is not whether it's legal in nature, but whether it admits of any discretion, which is why ministerial duties are distinguished from discretionary acts. A ministerial act is one like the delivery of an already signed commission, where there is a precise course accurately marked out by the law, which is to be strictly pursued. A ministerial duty arises when the legislature directs an official peremptorily to perform certain acts. By contrast, so you're directing somebody to do something. By contrast, in any case in which the executive, the presidency, when it possesses a constitutional or legal discretion, the official act is not ministerial. Now, as the court held in another case, a ministerial duty is a simple and definite duty, which nothing is left to discretion at all. If there is any exercise of judgment involved, the duty is not ministerial. Now, even the panel opinion admits that a ministerial duty is one in which nothing is left to its discretion. Here, even a moment's reflection demonstrates that avoiding violations of federal criminal law involves the exercise of judgment and of executive discretion. A statute that imposes a ministerial duty is one that commands a specific affirmative course of conduct that admits of no discretion in its execution. Criminal statutes do not command specific affirmative courses of action. Rather, they prohibit, okay, so it's not commanding, it's prohibiting certain specified conduct, leaving those covered with a wide range of discretion in how to conduct themselves to not go up against the breaking of the law. Now, given a prohibition in a criminal statute, a covered individual has an infinite array of options to avoid violating the law or breaking the law, thus rendering compliance discretionary within the meaning of Marbury. In fact, the government itself has contended that the emoluments clause is obviously not ministerial because it requires the exercise of your judgment. Now, the government also says that these statutes purport to impose duties on Trump as he exercises his official responsibilities overseeing the DOJ. He shouldn't have done what he did. That's what makes it ministerial. That's what makes it illegal. It's not discretionary, okay? Trump shouldn't have said those things. He shouldn't have done anything. So, and then all of that conduct, they say, it's just like filling out a form. So here, Trump exercised his duties. He was overseeing the DOJ, talking with cabinet people, talking with members of Congress, state officials. All of these things were about federal concerns. Also talking to the public. through official government channels. Obviously, all of these are discretionary. All of those things are discretionary. It's not ministerial conduct for which the president possesses discretion on how to carry out those duties. Virtually all the president's official responsibilities involve exercising discretion, which is perhaps why the federal courts have never, ever attempted to do this before. Now, second, the panel reasons that the cases following Marbury saying we can, right, this is what the Court of Appeals judges, we may review a president's actions when he's bound by law, including federal criminal statutes. But all the cases they cited to in the opinion, they do not involve the review of president's actions because this has never happened before, but a review of subordinate federal officials. They cited a bunch of cases don't even apply. As the opinion admits, this case reviewed the acts of a private ship captain, not the president. So like, thanks for that. This case cited the postmaster general, not the president. So who cares? And this one reviewed the Secretary of Commerce. Again, not the president. Who cares? Now, none of these cases provides any authority for why Article 3 courts are allowed to sit in judgment over a president's official acts. Those are subordinate people, not the president. And none of those cases contradicts the holding in Marbury that the president can never be examinable by the courts. So nice try, but it's not on point. In fact, the opinion from the Court of Appeals judges, right, they're blasting their opinion, it concedes. They say, they admitted Marbury and its progeny exercised jurisdiction only over subordinate officers and not the president himself. Weird. They admit it. But the opinion then pivots in a dizzying non sequitur. They said, yeah, the writ in Marbury was brought against the Secretary of State. In Little, it was against the commander of a ship. And this one, it was the post general master, or this was a Secretary of Commerce. But then in a non sequitur, they just jump right into it. They say, well, the Supreme Court has unequivocally explained that no man in this country is so high that he is above the law, which is like the dumbest phrase ever. It's just a platitude. It doesn't even mean anything, right? And of course, we have the pardon power that the president has, which articulates that. Now, the DC Circuit's reliance on highly generalized maxim that no man is above the law, it fails to provide a plausible basis for disregarding Marbury, Mississippi, or any of those other cases. Those cases and the separation of powers that are reflected in the Constitution are part of the law that binds the courts. This court held in a prior case that the contention that recognizing absolute presidential immunity places the president above the law is rhetorically chilling and wholly unjustified. I mean, look, like he's technically above the law in some ways, like he has the pardon power. So if somebody goes through a criminal proceeding and they're convicted, the president can say, no, sorry, I'm above the law and now you are too. You're gone, right? It's all done. That's the pardon power. Now, you could also say, well, the president has immunity. That would make him above the law, unless, okay, there's still a legal mechanism to withdraw that. So if the president does something that is illegal, he can be impeached and convicted. That's the end of the game. He can then be charged. So he's technically not above the law, right? There is recourse. Now, as the panel opinion overlooks, the remedy of impeachment demonstrates that the president remains accountable under this law for his misdeeds in office. There still is a mechanism. Okay, so stop with that no one's above the law crap. It's there. It's in the Constitution. This is especially true where the impeachment judgment clause specifically authorizes the criminal prosecution of a president. It says, go get him, but only after there's a structural check that's been put in place. You check impeachment and conviction. You got both of those checked off, then you can prosecute. It is simply error to characterize as an official as above the law because a remedy is not available against them. Now, the Constitution and the executive vesting clause, it is literally the most fundamental law that we've got. It's the Constitution. It's the root. And it dictates that Article 3 courts lack the authority to sit in judgment over a president. Here, the federal judiciary has sorely overstepped its proper bounds. Now, the judges, they also note that the president does not enjoy absolute immunity from criminal subpoenas. But compelling the president to provide information in response to a criminal subpoena, much different than putting him on trial, entering judgment against him, and maybe putting him in prison. And so thus, the justice in Marbury, he wrote, "The president's official acts can never be examinable by the courts." Now, they say below, President Trump argued that perhaps the most telling indication of a severe constitutional problem is a lack of historical precedent to support it. The unbroken tradition of not exercising the criminal prosecutions of a president despite ample opportunity to do this over centuries implies that power does not exist. That principle is neither new nor controversial. Our political history shows that President Trump has had, until now, has been the first in a line of a 234-year-long unbroken constitutional practice that tends to negate the power that is being asserted here. Now, the Court of Appeals overlooks this argument. It cites this other case, saying that the president is, quote, elected by the entire nation. It doesn't cite any other similar cases. It also declines to grapple with historical examples in the real world of former presidents accused of criminal behavior, none of whom in the 234 years ever faced prosecution, despite a political opportunity to charge them. They say American history abounds with examples of presidents who were accused by political opponents of committing crimes for their official acts. Tons of people. John Quincy Adams with his corrupt bargain with Henry Clay, making him the Secretary of State. George Bush, false claims that Hussein had weapons of mass destruction. How'd that work out? Obama allegedly authorized drone strikes to kill U.S. citizens and his teenage son. There are many other examples. Reagan's involvement, apparently in Iran-Contra. Clinton, his last-minute pardon of a fugitive financier, Mark Rich. Clinton's repeated use of airstrikes in the Middle East in August as an attempt to distract from Monica Lewinsky. Biden's egregious mismanagement of border security. Biden's alleged material support for terrorism by funding the UNRWA, despite its documented history of supporting terrorism. All this stuff being footnoted down here below. From the earliest days in the Republic until today, America is littered with examples of allegedly, quote, criminal behavior by presidents. But no one was ever prosecuted until Trump. The panel, the court judges, they also ignore the long history of real-world examples in actual behavior that other people have viewed as egregious and criminal. The panel from the court, they fretted about lurid hypotheticals, right, that have never occurred in 234 years of history and almost certainly never will occur, and would virtually certainly result in an impeachment and a Senate conviction, right? Obviously. They came up with the dumbest hypo in law. If they did occur, there's a hypothetical that Trump could order the assassination using SEAL Team 6. What if he orders them to murder Congress? Such hypotheticals provide fodder for histrionic media coverage way over the top, but they're a poor substitute for actual legal and historical analysis. Now, confronted with real-world hypotheticals, like when Obama killed American citizens, the special counsel conceded below that immunity from criminal prosecution for official acts, likely exists and would apply, directly contradicting the categorical holdings from the trial court Chutkan and the appellate panel in D.C. Well, yeah, I mean, like, this is crazy. Even the DOJ is not going to, like, the DOJ, I would imagine, is not happy that they even have to make this argument because the DOJ works for the president. Like, if they're opening the floodgates, I know they say they're just going to use it for Trump, but obviously that's not going to happen. Special counsel admitted that a drone strike where civilians were killed might be the kind of place where the court could properly recognize some kind of immunity. How come for that, but not other things like rigged elections? That's weird. Because it was your guy, Obama? Now, further, the logical presupposition of such a speculative hypothetical, for example, that the founders supposedly must have intended that no alleged presidential misdeed could ever escape prosecution, which was their argument. They said Trump wanted absolute immunity against all criminal charges forever. No, it's like absolute, but subject to an impeachment. So they mischaracterize it. They say it's plainly incorrect. It contradicts the basic premise of separation of powers. Thus, when the panel actually did get around to looking at actual history, It drew the wrong conclusions. They somehow proposed that there is no reason to fear a torrent of politically motivated prosecutions in the future because this is the first time since the founding that a former president has been federally indicted, okay? And so the prosecution of Trump is sure to just be a historical one-off, because January 6th was so bad. This reasoning is unpersuasive to followers of recent American history. For example, in the 209 years from 1789 to 1998, there was one impeachment of a president. That's it. Andrew Johnson, 1868. In the last 25 years, though, there have been 3. Okay, so we're on an uptrend. There have been 3, with the 4th currently under consideration by the House of Representatives. Isn't that interesting to think about? You just think about the cycle of empires, right? And you can just see it in the impeachment numbers. Like the political parties are now using, right, political blood sport to remove each other. And of course, they're indicting, people now, which is the subject of this claim. So presidential impeachment is changing from virtually unthinkable to a fixture of politics. Impeachment faces formidable structural checks. It must be voted by a majority and a supermajority in order to convict. Criminal prosecution, by contrast, all it requires is a single prosecutor with a compliant grand jury, and they just find those in the blue states. So for all these reasons, our history decisively favors granting federal presidential immunity. And if you don't, it's going to chill presidential action. Now, the court emphasized that the president occupies a unique position in the Constitution. Because of the singular importance of the presidential duties, diversion of his energies to deal with lawsuits is a big problem. The president must make sensitive and important decisions. And we have to be cognizant of that. Now, all of that came when we were talking about civil immunity. But all that applies to criminal as well. In fact, the concerns are even enhanced when we talk about crimes. The president's personal vulnerability to criminal prosecution with its greater stigma provides even more of a risk. The panel opinion disagrees. They say it doesn't matter, but their analysis is unpersuasive. Here's why. First, the Court of Appeals in D.C., it begins by drawing a comparison between the president's unique responsibilities and the deliberations of ordinary citizens called to serve as federal jurors. All right. Now, they say, we cannot presume that a president will be unduly cowed by the prospect of criminal liability any more than a juror would be influenced by the prospect of post-deliberation liability. Okay, they say that's a fun analogy, thanks, but it falls short. Though undoubtedly exercising an important function, a juror in a federal case does not occupy anything like, the presidency. A federal juror does not make the most sensitive and far-reaching decisions. They don't have sheer prominence in front of all these things, and so it's a bad analogy. Now, the per curiam opinion, again, they nudge that one. Nobody wants to own it. If your opinion was so good and so legally articulate and well-reasoned, put your name on it. It's not. That's why they didn't want to do it. They say, it also says that executive staffers create an argument. They say, but no, Nixon addressed the potential deterrence from candid advice. And this is going to lead to a chilling threat and personal vulnerability if the president is liable. They also say that past presidents have understood themselves to be subject to criminal liability. This argument ignores the enormous significance of the structural check in the Constitution. The founders were steeped in classical history. They understood that politically motivated prosecutions had already corroded their governments in Athens and Rome. They were thus explicitly concerned about the destructive effect on the new republic. James Madison described the newfangled and artificial treasons, which have been the great engines by which violent factions have usually wreaked their alternate malignity on each other. So they exercised care. They departed from British common law. They didn't want to treat the chief executive as absolutely immune in all circumstances, but they crafted and carefully balanced another approach. It authorizes the prosecution of a president, but only after both houses of Congress that reflect widespread political consensus actually convict the president by a majority 2/3 vote. After that happens, we know it's not political because there's a consensus. Even his own people are like, all right, this dude's a problem. He's got to go. Once that happens, then you can prosecute. Now, contrary to the lower court's ahistorical analysis that's not in alignment with history, this was the common understanding at the time. The criminal prosecution of a president could only occur if they were impeached and convicted by the Senate. This matches the views of Justice Marshall, Attorney General Lee, the same Attorney General under George Washington and John Adams. It's also in Marbury versus Madison. It's also talked about by Justice Story. And it's also articulated in the opinion in Martin. Now, there was also a clear and unambiguous understanding of Alexander Hamilton. The per curiam unsigned opinion states that Trump turns to one sentence written by Hamilton, but its math is off. Sorry. Hamilton wrote not once, but 3 times in 3 different essays. Oh, man. That the president may be subject to criminal prosecution only after he is impeached and convicted, and as a consequence of that conviction. He put this one in his writing. Alexander Hamilton said, the President of the United States would be liable to be impeached, tried, and, upon conviction of high crimes or misdemeanors, removed from office, and he's not done, and would afterwards be liable to prosecution and punishment in the ordinary course of the law. It's just logical. Like, it just makes sense that it works that way. To just say that anyone can prosecute a president at any time for any reason is insane. The punishment, which may be the consequence of the impeachment and the conviction, is not to terminate the chastisement of the offender. After having been sentenced to the perpetual ostracism from the esteem and confidence and the honors and the emoluments of this country, you're embarrassed because you got impeached and removed, he will still be liable to prosecution and punishment in the ordinary course of the law. He wrote that one, first one 69, next one 65. And he wrote this last one in 77. He says the president is at all times liable to impeachment, trial, dismission from office, incapacity to serve in any other, and to forfeit life and estate by subsequent prosecution in the common course of the law. Subsequent. After the fact. After you're convicted. Hamilton says criminal prosecution can only arise after and subsequent and afterwards and as a consequence and of conviction upon impeachment. Now, the plain implication is what it sounds like. That criminal prosecution, like removal from the presidency and disqualification, is a consequence that can come only after the Senate's judgment, not before. That's how Hamilton explained it. Now, the opinion from the so-called judges, it errs by disregarding this formidable and this carefully crafted structural check against prosecution of the president for their official acts. Conviction upon impeachment requires both the majority vote of the House and 2/3 of the Senate, which together require widespread political consensus. It requires representatives across the nation to agree. Now, criminal prosecution just requires one big fanny from Fulton County. That's all. And a compliant jury from Fulton. And the prosecutor, if she's clever enough, probably will be located in an enclave of deep political hostility, like in New York. Therefore, prosecution, which can only occur after impeachment and conviction, does not present the same chilling effect as a prosecution that can be brought by anybody. Now, Trump was already acquitted for the same conduct. And finally, for the reasons we already talked about, they say the overall assessment that this is going to impact the presidency is ridiculous. It cannot be squared with history. Impeachment of presidents, once something that was virtually unheard of, is becoming a routine feature of interbranch conflict. Once the Rubicon is crossed, which we've crossed it now, right? Like Trump didn't prosecute Hillary, although she wasn't a president, but maybe he'll prosecute Joe. I mean, what's good for the goose is good for the gander, as they say. Once the political Rubicon is crossed, criminal prosecution of presidents by their political opponents will be common, and the threat of such prosecution will become ubiquitous, hanging over every president like a sword of Damocles. And instead of acting fearlessly, every president is going to be tiptoeing around their position. Enterprising political opponents, like the left is already doing, aware of this, will wield the threat of prosecution as a powerful and menacing tool, and this will wound the presidency for the future. Now, Trump is going to suffer irreparable harm if you grant the opportunity for them to continue this trial. Absolute immunity also prevents the trial. Trump has already been tried. He got acquitted in the Senate. That's double jeopardy. Now, the opinion strongly endorses our conclusion. They say they have jurisdiction over this. And so these statements cannot be squared. They say Trump is going to be injured because it's going to harm his First Amendment rights and ours as Americans. They say the D.C. Circuit Court of Appeals and their extraordinary decision to give this case back to Chutkan, it threatens the First Amendment rights of all Americans and Trump. The special counsel seeks to urgently force Trump to go to trial and be in a months-long criminal trial at the height of the campaign season. They want to sideline him while he's running against the current president, to whom the special counsel ultimately reports, that's Joe. This would impose grave First Amendment injuries on Trump and us, the American people, whether they support him or not, and it threatens to tarnish the federal courts with the appearance of partisanship. Losing First Amendment freedoms is a big problem. Here, Trump is the leading candidate for president. He's the greatest electoral threat to Joe, whose administration is literally prosecuting him. Conducting a months-long criminal trial of the leading opponent by the leading opponent of the current regime in the middle of a presidential campaign is going to disrupt Trump's ability to campaign, and it's going to hamper our ability to hear from him. The speech of a presidential candidate is the pinnacle of First Amendment protections. Likewise, the First Amendment constitutional guarantee should overcome all of the other limitations. It extends first and foremost to the American voters, right? And when they were banning Trump off X and all the places, it was offensive not only to him, but to us. Okay, we wanted to hear from him. The First Amendment's protection is afforded to the recipients as well as the communicator. And this court has never allowed the government to be prohibited from communicating information to their voters. Permitting Biden to put its leading political opponent on trial in the middle of a campaign would do exactly that. Stifling Trump's campaign speech for months on end with the election date less than 9 months away. Now, since this is not a closed case, court, you need to accept this. But if it does not automatically accept it, follow the equities. Here, there was a 234-year tradition against prosecuting presidents. Now, all presidents can be blackmailed and extorted. Trump is going to undergo a criminal trial. They're trying to make him go through this before his immunity claim is even adjudicated. That's what they want to do. This violates his rights. Now, again, against these compelling interests, special counsel cited only one consideration about why we need to go so fast. Jack says, it's imperative. We have imperative public importance, and we need a prompt resolution of this case. All this they want to do while Trump is campaigning against Joe Biden, and that's who Jack Smith is working for. Now, in the Court of Appeals, as here, Jack never explains why. Why, Jack? Why is it so imperative that this case proceed to trial immediately? How come? The prospect of an interlocutory appeal of an immunity question might even, he says, this is common. We do this all the time. There's delay in all sorts of appeals. So why do you need this to go so quickly? Well, it's because of the trial. The special counsel confuses public interest with partisan interest. The public doesn't have an interest. You do. Their politicization of this trial goes against the best traditions of the DOJ. Even worse, they're tarnishing the Court of Appeals. They're making them appear partisanship by having them go very, very fast. They say, haste makes waste is an old adage. It has survived because it's right so often. The court should stay the D.C. Circuit's mandate pending resolution, and if a review is granted, let us address this on the merits. Trump also requests that the D.C. Circuit mandate is stayed pending the resolution not just in this Supreme Court, but also for the planned en banc appeal, which is going to add more time. We have the right to en banc appeal, and we're going to submit that here, saying that this court, in conclusion, should stay Judge Chutkan's case and the Court of Appeals mandate to return the case back to her desk, Keep postponing it until we resolve this. Signed by D. John Sauer on behalf of President Trump. And you can see the rest of this document are going to be the lower level court rulings and the filings. This is from the DC Circuit Court of Appeals. And so we read through all of that historically previously here. But nice motion from Trump's defense. Of course, this had to be crafted very quickly because they gave them basically no time. But some very good historical points there. I think they went through the lower level opinion. They pointed out some of the incongruities, the inconsistencies that we saw. I really like the 3 Hamilton quotes, right? And that type of pattern is something I think we'll see more of. So they said, well, here's one quote that supports us. They say, well, here are 3 that do not. And what I notice is they're all right there. I think these lower level courts are just focusing on these cases. They want Trump to have no immunity. Supreme Court doesn't really care about Trump. The case applies to Trump, but it's about the future of the executive branch. They have to live with their decisions etched in the history books for all time. And so they're going to be very concerned about jettisoning presidential immunity and wrecking the executive branch on their watch. We have some other reaction to this. MSNBC's hit show, you know the name, Jen Psaki is here, and she brought this guy on. Remember him? Cyrus Vance. He is the former Manhattan district attorney, the guy who came before Leticia James did. And she brought him on to talk about how this is going to go at the United States Supreme Court.
Yeah, I mean, as you just said, which is in a very important point, there's ample precedent here, even before your case about presidential immunity. It's been argued many times before. Chief Justice is still the Chief Justice of the Supreme Court, who is the one I just quoted at the end of that. I know you said you don't want to predict, and I know most people aren't in the prediction game, but even looking just at the law here, do you think they would have any legal case to be made to grant him this immunity?
Absolutely. Absolutely.
I think the precedent that has been set, which was reaffirmed very strongly by Justice Roberts in Trump v. Vance, would lead the Supreme Court to be comfortable with saying that the president is not immune from prosecution for prior acts while he is no longer president. I think it's not debated, at least in the federal context, that the president wouldn't be charged by federal prosecutors while he is president or she is president. But that's not where we are. And I think we set I frankly think we set a very dangerous precedent where we permit someone who was president, who deserves protection from the law and safeguards that ordinary citizens don't have. And he got all of them and more in every matter that he's taken to the Supreme Court. But ultimately, as all the justices have said from decades ago to 2020, the president is at heart a citizen. And when he or she is a citizen, they are not immune from responding to law as any other citizen would be. And it would be terrible if that wasn't so.
All right, not a lot of legal analysis there. I don't even know what he said that was meaningful. But okay, so that's his reaction. He just, more platitudes. Pelosi was out. I think she was off the sauce for a little bit. She showed up and hung out with Anderson Cooper, and she's talking about why Justice Thomas really needs to recuse himself from this entire ordeal. And so this is going to be a lot of what we hear about. The Supreme Court, I'm fully anticipating, is going to come back and get rid of the Colorado ballot removal case. They're going to say, you guys are psychos, stop trying to do that stuff. Here, we'll see what the Supreme Court does, but they're already trying to undermine their rulings. Okay, here's Pelosi with Coop.
Democratic Congresswoman Nancy Pelosi, former House Speaker. Madam Speaker, thank you for being with us. So the former president is trying to rewrite history, ludicrously now claiming you were behind the insurrection at the Capitol, saying he should have total immunity. You've seen a lot of presidents up close. If a president had total immunity, as Trump claims, what would that mean? What would that actually look like?
That would mean that, hi, Anderson, nice to be with you.
Hi, Nancy.
That would mean that this president thinks that he is above the law. And I think that he is on trial for certain things. I think the Supreme Court is on trial as well to see if they would uphold the decision of the D.C. District Court and the 4 votes to hear it, 5 votes for a stay. How could they possibly give a stay for justice to proceed? How could they possibly give a stay? So
Well, because they've accelerated it a lot. It's a pretty complex issue. There's really no need to rush it. Like normal proceedings take some time. Like these are long things. They sometimes take years to flesh these issues out. But your side just wants to race it. So, I mean, the reason would be because it's normal to go slow.
This is really, again, he always thought he was above the law. He's trying to make that a case. That's not what our founders had in mind. They knew there could be a rogue president. I don't think they thought there could be a rogue Supreme Court as well.
Do you have confidence?
Wow, so she's talking garbage against the Supreme Court. That's Nancy Pelosi.
Supreme Court, I mean, should Clarence Thomas have recused himself given his wife's activities?
Oh, here we go.
Absolutely. Well, he should have for a long time. But the rules of the Senate, the protocols of the Senate are such that they really are not living up to a high ethical standard. And he should have been recusing himself. But they say their rule is that it's up to the person to recuse themselves. They have no peer pressure or anything to address that. But his wife is so involved in everything that was happening on January 6th, bragging about it. And there he is.
I spoke to former Governor Chris Christie last week. He said he thinks it's likely the former president will be accepting his party's nomination in July as a convicted felon. Do you think Trump will actually stand trial before the election?
She wants him to.
Who
so
knows?
bad.
This is a person whose sanity is not on the level.
Oh, gosh.
Thinks he's above the law.
You just said that 4 times already.
National security risk. And just listen to his own words about encouraging Putin to invade countries that may not have paid what he thinks they should pay for NATO dues, and that we will not honor our responsibility to NATO Title V to protect them, just as they joined in protecting us after 9/11. We would not honor our commitment to them. So we're dealing with somebody who's not on the level.
Okay, she said that like 4 times. It's weird. It's almost like she doesn't even have anything to say other than the talking points. It's like, yeah, I'll just go on and do Cooper show. Well, you're going to talk about some, Supreme Court litigation, and she just says no one's above the law, 5 times, and Trump is, like a psycho or something. So that's her analysis. Strange stuff. She's not far off. Her protege is Crazy Eyes Griswold, and she is now saying that if Trump is on the ballot, it is suppressive to the rest of, I think, the people in Colorado. So this is going to be the new line. Here's Crazy Eyes with her speech.
States like Colorado believe that it is confusing and potentially suppressive to put a candidate on a ballot who cannot assume office. That's why, just like that non-natural born citizen, we kept Donald Trump off, because he is disqualified from our perspective under the Constitution for being an oath-breaking insurrectionist. States
for being an oath-breaking insurrectionist. And watch this face right here. There it is, right? There it is. That's Crazy Eyes for you. Oh my gosh, be careful out there. All right, so it would be suppressive. Okay, so remember, one of the arguments is that the ballot is, Trump is allowed to be on the ballot, but he cannot hold office, right? That was the distinction. They said, well, the law says he can't hold office. So he could run, win, and then Congress could remove the disability. Let's say that Jenna Griswold is right. She's not actually as Crazy Eyes as we think she is. She's right. The Supreme Court comes back out, says 14th Amendment applies to him, and he should be removed. Then the argument is that the holding office is different from running for office. So if they come back and find in her favor, obviously he's not going to be on the ballot. But if not, he could always run, win, and then be precluded from taking office, right? And then there could be a 2/3 disability removed from him, and then he could take office anyways. But she is saying, okay, look, even having him on in the first place is suppressive. So they are doing everything, and she's counting the votes, right? These are the people who are going to be counting the votes in the foreseeable future. So Kyle Cheney actually did the math, which is much appreciated because you know how much we hate that here. But he said this, look, Trump's immunity appeal, that was paused back on December 7th. Remember that. 88 days to go until the March 4th trial was set to begin. That means if SCOTUS sends the case back to Chutkan, she's going to give Trump roughly 88 days to prepare for trial. Now, if SCOTUS grants the stay, takes up the immunity issue, and resolves it by April 20th, Trump trial could begin in mid-July, right? So SCOTUS takes it up, kicks it back down. Chutkan says, okay, we're going to trial again. Whatever day they come back, they're going to add in those 88 days and throw it up to the top. If SCOTUS denies the stay, let's say on Feb 22nd, that would line up with Trump's trial for May 20th. He could also go back on trial in Florida, although that's highly unlikely. Of course, if they accept Trump's immunity argument, the case is dead and dismissed. So you can see, like, we're getting pretty close to the drop dead date. May is a possibility on that. And, you know, gosh, I don't even know. I mean, Chutkan, I think, might have a trial in July, you know, because that's how much they want this to go. So Trump knocking on the door at the United States Supreme Court. Jack Smith has been ordered to issue his reply by February 20th. Of course, we are going to be here and continue to cover all of the Trump trials everywhere in Florida, in Georgia, the 2 special counsel cases, Alvin Bragg, the ballot removal cases, all of them. We're covering them all. So thank you for subscribing, my friends. Thank you for inviting someone over here to join us. We go live every single day of the week. We'd love to have a friend come and join you here on our lives. We'd also love it if you liked our video and checked out some of the links in the description below. We have watcherlodge.com now. We have some great events coming up. Zen Wellness, food sovereignty workshops, a lot of fun stuff. So make sure you check out watcherlodge.com in the description below, because we're going to have to be learning some sovereignty and self-development skills in the future. And we're going to be here continuing to cover all of the Trump sagas. I hope you join us as we do, my friends. Thank you for subscribing. We'll look forward to seeing you back here on the next one. All right, we're not done yet. We got one final segment on the day. And this time, we're going up to New York. Leticia James gets a big fat bar complaint from Representative Elise Stefanik. It's a good one. 64 pages. Tish, of course, is the person responsible for bringing the civil prosecution, we're calling it, against Trump and his businesses. We're waiting for Judge Engoron, aka the Areola, aka the Nip, to come back out and issue his ruling, finding out if Trump's going to be fined $300+ billion. But Stefanik sent in this monster bar complaint saying this woman is not even legitimate to practice law. She has violated her ethical responsibilities, and she's got to be booted out of the system. Trump is responding to Tish, and we know who this woman is, but if you're just joining us, not real familiar with her, she's the person trying to destroy Trump's New York businesses. And she ran for office advocating about stopping Trump. She's the Attorney General for New York, and she has been sitting in the same pew in the trial for weeks. And we're awaiting a ruling. This is the person behind this, Leticia James.
And what would you say to people who say, oh, I'm not going to bother to register to vote because my voice doesn't make a difference, or I'm just one person?
I say one name, Donald Trump. That should motivate you. Get off your ass and vote.
Will you sue him for us?
Oh, we're going to definitely sue him. We're going to be a real pain in the ass. He's going to know my name personally.
I love it. He probably does already.
This illegitimate president who sits in the White House.
That president, because he's not my president, he's an illegitimate president. His days are numbered. His days are numbered.
We've got to get ready to mobilize, and we've got to get ready to agitate and irritate until victory is won, but more importantly, until Trump is defeated.
As the next Attorney General, I see the law as a sword and as a shield to protect those who are vulnerable, because no one is above the law, including this illegitimate president. And so, I look forward.
Isn't that insurrectionary language? Like, how is she getting away with that? Why isn't she indicted and thrown in the gulags?
I look forward to going into the office of Attorney General every day, suing him, defending your rights, and then going home.
And at the eye of the storm is Donald Trump, ripping families apart, threatening women's most basic rights, and running for Attorney General because I will never be afraid to challenge this illegitimate president.
Did you see her facial spasm? Did you see her facial spasm? That's how demented she is, okay? That's TDS right there, look. This illegitimate president, okay? The whole face is twisted up. It's like the dark side, man. Here it is, one more time.
and running for Attorney General because I will never be afraid to challenge this illegitimate president. He should be charged with obstructing justice. I believe that the President of these United States can be indicted for criminal offenses. It's important that everyone understand that the days of Donald Trump are coming to an end.
Will you sue him for us?
Oh, we're going to definitely sue him. We're going to be a real pain in the ass. He's going to know my name personally.
All right, so that's this woman, okay? Now, she gets a big fat bar complaint, and one that couldn't even be more deserved. This comes out from Elise Stefanik. Here is what she says. From Representative Elise Stefanik. Of course, this is not on her official government letterhead. It is from Elise Stefanik personally. She lives apparently in Glen Falls, New York. Now, she sends this over to the Committee on Professional Standards for New York, the committee that governs bar licenses. And you can see this monster is 64 pages. Shout out to Elise Stefanik. Woo! Look at all these documented statements that are inside this filing. Lots of messages. And let's see what she does to assemble them all. Lots of research here. The complaint against Tishy Letish says, all right, New York. New York Attorney General Leticia James violated the rules of professional conduct. She has attacked President Trump and made extrajudicial statements during a trial. That's not what lawyers are supposed to do. In just the first 5 weeks of the trial that began, and before I stopped counting, Miss James made over 50 highly inappropriate and prejudicial comments on social media. This complaint respectfully requests that Attorney Grievance Committee conduct an investigation and issue an immediate interim suspension and disbar Miss James as an attorney and a counselor at law, or suspend her. Now, the investigation and the trial of Trump are matters of enormous public concern. All citizens like James have First Amendment rights, but as a licensed attorney, Tishy is subject to specific rules and responsibilities under the code. They create specific restrictions that apply only to attorneys and not to other citizens. And that's why she is busted. So here's the story. They say, as an attorney licensed in New York, Ms. James is subject to the rules of professional conduct. You have a license, there are rules, they take it seriously. They give us some background. It is well settled that rules of professional conduct also apply to public officials. The rules say that as an officer, each lawyer has a duty to uphold the legal process, to demonstrate respect for the legal system, to seek the improvement of law, and to promote access. In addition, a lawyer should build confidence in the rule of law and, in a constitutional democracy, maintain their authority. All right. Now, violation of the rules may be professionally disciplined if you violate those. Now, this committee has the ability to go after Tish. So here's the specifics. They say, Miss James, the reason why she needs to be disbarred and suspended immediately is because she ran for office with a personal vendetta against Trump since he was first elected president. Her comments as AG reflect adversely on her fitness as a lawyer. The rules say she shall not engage in conduct that reflects on her fitness as a lawyer. But she has. She has engaged in a ton of different appearances, press conferences, legislative hearings, radio broadcasts, podcasts. She's gone on television appearances and she's made court appearances. And all of this was improper. Now, before she became a candidate for the AG, James displayed extreme partisan hostility towards Trump. During Trump's first year in office, James led die-in protests against Trump. She said, we're all being killed by this administration. She accused Trump of blatant disregard for human lives. She talked about Trump and saying she's leading the resistance against Trump, and she's going to continue to do so in every way. She also campaigned for Attorney General, explicitly focused on him. During her campaign, she called him a con man. She called him a carnival barker. During a debate, she said that she promised to focus on Trump if she were elected. Her obsession continued in 2018 during her election night victory speech. She said her victory was, quote, about a man in the White House who can't go a day without threatening our fundamental rights. She said she was going to expose this. Now, during the transition period before she took office, James promised to use every area of the law to investigate Trump, right? She had a vendetta from day one. She also leveraged her campaign attacks into fundraising appeals. In 2018, she posted a message to Act Blue, which is a Democrat Party and candidate fundraising platform. She said, "In this fight against Trump and this harmful administration, I need your help." She did not just promise baseless investigations into Trump. She also prejudged evidence that she had not even seen. She called for criminal charges. She said that she made it clear that Trump would be her top target. She told voters she'd been elected because Trump should be indicted. Before the primary, James also specifically called for Trump to be indicted on criminal charges. She said obstruction, accused him of money laundering, all these things. She said Trump's days of defrauding America are coming to an end. Since day one, she was running on this. Now, she's displayed a personal vendetta, Tishy, against Trump, making her unable to impartially handle these cases. She used promises of investigations to raise money. Despite her bias, she launched frivolous investigations and other lawsuits. She prejudged evidence that she had not even seen. She called for indictments without seeing any evidence. It should go without saying that this is an abuse of an attorney's position. And as a lawyer, Miss James should not have made these comments about Trump. Having made these comments, James should have recused herself from any official action by her office involving Trump. Even legal commentators who politically oppose Trump have said she's made some bad statements. You know, Dan Goldman, the guy who bought his Congress seat in New York, he served as the lead counsel for Democrats. He warned that James's statements give an appearance of an individualized vendetta. He says it's important for prosecutors to maintain their neutrality. This guy called Chuck Rosenberg, who worked with Robert Mueller, said that James should consider recusing herself from matters involving Trump because she has demonstrated a prejudgment of the facts. Every good prosecutor knows those comments are a problem, they said. Rosenberg said Miss James should recuse herself again. Now, as the Supreme Court said in a case involving Trump, the law seeks to protect against the abuse of politically motivated prosecutors. And Miss James and her extreme partisanship, her lack of impartiality, her personal vendetta, jumping to baseless conclusions, really question her fitness as a lawyer under Rule 8.4H. And her refusal to recuse herself is also something that adversely impacts and reflects upon her fitness. If the committee determines that she did violate the rules, she should be disbarred or suspended. Now, here's the background further. In September 2021, James filed a civil suit against Trump and his businesses. From the very beginning, she was constantly attacking him. She was publicly commenting on and mischaracterizing the evidence. She made a bunch of Twitter posts attacking the credibility of the witnesses and others. At press conferences announcing the lawsuit, James accused Trump of violating the law. She said, "For too long, powerful people like Trump have operated like the rules don't apply to them." And she went on a big speech. She has held other press conferences and so on. She has also communicated through social media about the trial. Just during the first 5 weeks of the trial, Tishy posted about Trump and his family more than 50 times on her X account. As of November, when I stopped tallying, these posts have been viewed more than 54 million times. Screenshots are attached. Her comments during the lawsuit and the trial looks like those violate Rules 3.6 and Rules 8.4. Rule 3.6 governs trial publicity. It says a lawyer who is participating in a trial shall not make extrajudicial statements that the lawyer knows is going to impact the public. Knowingly, right? And they say Tish clearly did that. During the trial, Tishy repeatedly made prejudicial public comments about Trump. For example, in the first 5 weeks alone after the trial began, here's what Tishy said. "When it comes to running a company, Trump doesn't care about the facts. He engages in fraud. Trump and others have committed repeated fraud. Regardless of Trump's fantasies, his inflated net worth caused fraud. Said that he filed fraudulent statements, says he's committed repeated fraud, and so on." Okay, she's just running her mouth every day on X. Here are all the posts. New York State AG, State AG, State AG. She's posting like mad. Okay, all of her other statements are there. Now, she's also accusing Trump and other Trump family members of having lied. During the trial, she repeatedly accused Trump and his family members of lying. She made that statement. Said Trump fraud is very real. Here's another one. We've proven Trump lied about his net worth. Trump might lie, but the facts and the numbers don't. Trump can keep lying. Eric Trump also pretended not to know, and so on. Okay, those are all of her posts. Those are all of the X's, one right after the other every single day after trial. She also made personal attacks against Trump. During the first 5 weeks of trial, she launched personal attacks against Trump. Says the Donald Trump show is over. Trump lives in fantasy land. Trump is fomenting violence. Trump's race baiting. Trump is baseless. Trump is making dangerous and racist comments, and so on. Right? Trump is a bully. All of these statements, she can't get enough of it. It's her whole life. And her comments violate the rules. James is participating in the civil lawsuit and the trial. She brought the lawsuit. It's her office. She also personally attended the trial and sat in that pew that's going to need to be replaced. She also made numerous extrajudicial statements. She held press conferences. She gave interviews. She posted more than 50 times in the first 5 weeks. Many of those posts included videos. She discussed her views and evidence that came into court that very day. All right, so she is talking about stuff that matters. She's also disseminating this stuff publicly. They know that Trump is a presidential candidate. She's seeking global media attention. She knows, or reasonably should know, that these statements are going to be spread far and wide all over the interwebs. Now, as further evidence of this knowledge, she has specifically sought out national attention. She announced the lawsuit got national attention. She's been, milking the cameras for years now. Ms. James has also publicly and personally disseminated extrajudicial statements. She's posted on X more than 50 times. She's got over 500,000 followers. Engagement is big, 54 million views. So she should know that this is going to be disseminated into the public. And of course, the law and the rules say you can't do that. James knows that her statements are going to have a substantial likelihood of prejudicing Trump. Her conduct supports an inference that she's deliberately intending to cause the public opinion to shift. Her extrajudicial statements are being made to the public and being spread around. Now, it's no defense that others like Trump have commented on this. Trump is not a lawyer subject to these rules. James is also a client. James's client is the state of New York. And the state of New York has not been the subject of criticism as a result of the trial against Trump. Her comments would also only be permitted if they contained necessary information to rebut other statements. But those are affirmative statements. She's not responding to any other statements. Now, Ms. James's accusation of fraud, it goes against the rules. It violates the restrictions on public trial publicity, and it adversely impacts her bar license, is what they say. James's comments also raise serious ethical concerns. Prosecutors are held to high ethical standards for their extrajudicial statements. 3.6 restricts these statements. Prosecutors are held to higher standards to protect defendants because they don't have the power. Defendants don't have any power. The government charges you, and then they can go and talk about you using all the media. In May 2021, James announced that she was opening a criminal investigation into Trump. She also formally partnered in the criminal investigation and assigned at least 2 other DAs to do the work. She filed her civil lawsuit. In April, they announced a 34-count felony indictment of Trump. That's the business records case brought by Alvin Bragg. And apparently, James is also considering indicting Trump on RICO. Wow. The November 2023 report says she's still considering that. But this is why her comments are bad. She's made extrajudicial statements. She's disseminating actual knowledge about this case. The things she's saying could prejudice this claim. And so we have to suspend her. In 2021, the Attorney Grievance Committee suspended Rudy Giuliani. They evaluated several factors. Seriousness of the offense is a factor. They also talk about the misconduct is continuing. Here, Ms. James is ongoing, right? She continues almost daily to talk bad about Trump. It's expected that an appeal is going to be filed, and she keeps making statements. This is also a serious problem because she's made over 50 social media posts about all of this. It's going to result in a high sanction if it is determined that she is violating the rules. And so therefore, because there is an immediate threat to the public, the committee should seek an interim suspension of James's license, saying, James violated multiple rules of professional conduct. I urge the Attorney Grievance Committee to suspend her, remedy the significant ongoing harm, suspend her, or disbar her immediately. Signed by Representative Elise Stefanik into the Attorney Grievance Panel in New York. And so here are all the rest of the appendices. Here you go. James said this: 1 year ago, we filed a lawsuit, Trump's financial fraud, right? Here's another one. And more X's. She's posting all over the place. She's got timelines here. She's got photos. Look how powerful I am. And I'm heroic. I'm saving America. Okay, here are all the rest of her posts. A lot of posts here for a prosecutor that's not supposed to be talking too much about any of this stuff at all. She's very vocal about it because it's her whole basis for existence, right? They don't really have much else to live for. So that's what they do instead. Now, Donald Trump responds to this. He says, all right, Leticia Peekaboo James is a corrupt attorney who knew nothing about my tremendously successful business, but still campaigned on, I will get Trump. Indeed, the actual witnesses in this contrived and baseless case established that my net worth exceeded that which was reported in my financial statements. And those statements never included my most valuable asset, which is, of course, the Trump brand. The politically biased judge, Areola, on this rigged case refused to acknowledge that the appellate division has already ruled in my favor on the statute of limitations and effectively ended this litigation. The judge has overturned 4 times during this trial alone, a record. He is out of control. A political operative who valued Mar-a-Lago at $18 million when it's worth 50 to 100 times that amount. And so Trump responds to Tishy Letish. And of course, we are here awaiting the ruling from Judge Engoron, aka the Areola, aka the Nip. And he is very likely going to be disgorging Trump or fining Trump of $100+ million. And so, my friends, I hope you are joining us when we get there to cover that. Thank you for subscribing. Thank you for hitting that like button. Thanks for inviting someone over here to come join us during our weekly live streams every day. We got a lot to talk about, all the Trump trials, and of course, the ballot removal cases. And so we'll be here covering it. Don't forget to check out some of the links down in the description below. We got some great events coming up in February at watcherlodge.com. Free to join the events. If you want to become a lodge member, got to pay for that, but the events are free for now. So come join us. We got Zen Wellness coming up and a food sovereignty event coming up next week. So it's going to be a lot of fun. watcherlodge.com. We're going to be here covering Tishy. We're going to be covering Fanny. We're covering Alvin Bragg. We got Deranged Jack Smith, all of it here. And we'll look forward to seeing you right back here on the next one. All right, my friends, that is it for us on the day. We covered some good ground. DISBAR Tishy Leticia James, because she is partisan and a hack and not someone who should be practicing law. And we also read through Trump's full petition to the U.S. Supreme Court, and we got a lot of activity on that one. Jack Smith's reply due a week from now, and we'll see what happens there. But now, my friends, it is time to hear from you. Let's see what you have to say about this. Of course, we are going over to watchingthewatchers.locals.com after we're done here for our members-only after party. And we'd love to see you there. We do streams in the morning, we do streams on Saturday, and we do after parties, so come and check us out. If you're on YouTube and you join as a member, you can join the after parties, but you got to navigate over on the YouTube channel homepage to the community tab, scroll down a couple months, grab the private Telegram link. We'll see you there. Who is joining us today in the house? First one on the day. Actually, this one came in yesterday. I think we missed this. We did. We missed this yesterday. So yesterday, Andrea says, as a legal immigrant, I'm offended by the illegals. I would be too. I would be too. I mean, you came the right way. You did everything appropriately. These people are coming across getting credit cards. It's wild. Good to see you, Andrea. Thanks for doing it legally. We're glad to have you here. We very much appreciate our legal immigrants. Good to see you. We also got some more donos in the house. And let's see who is joining us on the day. I got to get my scroll right. And obviously, I'm going the wrong direction here. We got some amazing friends clipping away for us, and so grateful for you guys. Let's see. This one from Fact says, a sentence or two from Trump's brief was worth reading. This threat will hang like a millstone around every future president's neck, distorting presidential decision-making, undermining the president's independence, and clouding the president's ability to deal fearlessly and impartially with the duties of his office. It's a great line, Facts. It's a great line. We read that one today. Thanks for that. Hey, and Call Me Legend says, thanks for your analysis every day. Thank you for that. Call Me Legend. All right. In the house. Thank you for that. Thanks for the nice dono and for being a member. Call me. I appreciate that. We got John Lynn is in the house as our newest supporter and upgraded to the shout out status. Very good to see you, John. Thanks for being here and joining us. Glad you made it. We got Tony Hayes bringing in 5 new members, including Cheryl P., Chinny Wynn, Muffin Randos in the house. Zach Guy's joining us, and John O, all being gifted members, courtesy of Tony Hay Munkets in the house. Thank you, Tony, for bringing in the new members. Hey, Zach R's coming in. What's up? We got some new members today. Welcome aboard, Zach. We'll see you in the morning for our members-only stream. John McGarvey's bringing in 5 new members, including James K., LMC, James B., Snake Pliskin's here, and Jim Gerard, all coming in courtesy of John McGarvey. And John, thanks for bringing in our 5 newest members. Very grateful for our newest members, courtesy of John. Patrick P's in the house, 16 months. That is almost 2 full babies in the house. Patrick Parker, been a member for 16 months, says, woohoo, 16 months and going strong. Is Bend Over in? I don't know. Is Bend Over in the Membo community? It's a good question. Thanks for being here, Patrick, for 16 months, man. It's been a long time. We've seen a lot of stuff together, no doubt. What's up, Don M? Don M became a supporter as well. Welcome aboard, Don. Great to see you. We'll see you on the members-only streams. We got Rob, says, Rob's on Rumble, says, I think Comey and Obama met with Trump and said, you better do what we say or we're going to ruin you and your family. And Trump said, go ahead, make my day. Gave him the middle finger. Bang, Trump collusion, Russia hoax. Yeah, probably something like that. Maybe not Comey and Obama, but maybe, maybe someone else did something like that. We got Tony Hay with 5 new membos. More from Tony. Thank you, Tony. Bringing in Janine S., Pond W., Lil Mandy's in the house. Chetty M is here, and the old bag just came in, courtesy of Tony Hay Munkets in the house. We got Ray Ronk. Ray Ronk says, Rob, I hate to bring this to your attention, but I cannot let my minor child read the chats during a stream because they are so crass. Yeah, we try to keep it as family friendly here as we can. I try to avoid some of the stuff that's a little bit more, crass, because I know it is a family show. We'll try to keep it a little bit more PG. We've had some interesting topics these last couple weeks because of Fanny's indicting Wade. It's like wild. We're trying to deal with the spillover, of course, but there's only so much you can do. So Ray, shout out to your son and shout out to your household for keeping things nice and clean over there. I appreciate that. And thanks for bringing it to our attention. We got Dolphin Fan is the man, bringing in new membos, including Stephen Barbaric Brit is here. Ray M. Roger Needham is in the house. And Alex Jones. Alex Jones! What's up, Alex? Welcome to our membership community. Hopefully he brought the documents. We got Rob says, beginning in 2024, under President Trump, America will be the top exporter of illegal aliens. That's a great point. Yeah, that could be true. Yeah. We were the biggest recipients. Now they were the biggest deporters. We got Glocky says, holy moly, a little off topic, but CBS just fired Catherine Herridge, which I saw that, man, as I was sitting down. I didn't see it was confirmed, but I saw the rumors of that. She's probably one of the best national defense and intelligence reporters. She does actual journalism. Yeah, I really like Catherine Herridge. I can't even really name another mainstream journalist like She's great. She does great work. Of course they fired her. She's probably a little too onto something. We got Sassy says, hey, what's up, Sassy? Welcome, our newest supporter. Sassy's in the house, a membo. Welcome aboard, Sassy. Great to have you. We'll see you on our member streams. Tony Hayes bringing in more membos, including Rye B. Hey, Sean's in the house. We got Kevin G, Don G, and Kevin H all coming in, courtesy of Tony Hay, the man. Pritchie says, I joined the stream an hour late again, but I'll catch up. Pritchie, we're going to have a talk about this, okay? You're going to have to, get this settled. Super Buff is here, says, Rob, what time is your show for Thursdays as we do our deep penetration into Fanny's case? Yeah, it's going to be a full day, I think. What time does the hearing start? 9 a.m. is when a lot of court proceedings start. So that would be like, we're going to start like when it starts. So whenever it starts. So 9 a.m. Eastern time, I think, probably. Eastern time, probably. Maybe. Is going to be the one. And it might go Friday, too. It's going to be a doozy. Glocky says, why in the heck haven't Trump's law team brought up the fact that Smith wasn't legally appointed? They probably think it's not their best argument, I guess. So they're choosing not to pursue that for whatever reason. I don't know. It's an interesting one. But I haven't seen them bring it up yet. Glocky says, this dude is saying Trump isn't immune because he's a citizen, but Trump is being tried for statements he made while president. It's a great point, Glocky. Yeah, it's a great point. I don't know that dude knew much about anything, but you're right. Glocky says, Anderson is saying that it would be scary if presidents had full immunity, but that last clip of that prosecutor said that SCOTUS already said presidents have immunity. What are these clowns even saying? It's a good question, Glocky. We try to figure that out regularly here. We got Knox says, good evening, all. The bottom line is the incumbent has oatmeal for brains, talking about Joe, and he should be in a home. The party really wants a single name on the ballot. Insane. Yeah. We have oatmeal Brussels sprout brain and Joe Biden. It's not good. We got Rob says, so according to Pelosi, is saying that DC court is above the Supreme Court. Yeah, basically. Yeah. Pelosi's husband was so involved in insider stock trading, taking our money, maybe Congress can indict them for public trading violations. Hey, Glocky says, has she suppressed D's? D's what? Rob says, Dan Bongino analyzed a video today showing a bomb-sniffing dog that went right past the bomb found in front of the DNC. Didn't smell any explosives because it would have went up and found it. I saw that. I think Julie Kelly posted that, right? Julie_Kelly2 on X is reporting on a lot of that. Tony Hayes bringing in new membos. Melanie H. James P's coming in. Marjorie S., Chris S., and Boiler Operator, all courtesy of Tony Haymunkets in the house. We got Sandy says, my prediction is that SCOTUS rules on the J6 1512C case as one of the last cases at the end of June, but the immunity case doesn't get a ruling this term, leaving Jack to realize 2 of his 4 charges are dead in the water. How does SCOTUS allow Jack to come speak in front of them when he's unlawfully appointed? Where will the Solicitor General be in this phase of the case? All good questions. Yeah, and that's another possibility too, because Jack Smith is charging him with those same types of crimes. Michael Manson says, that's one evil woman who's been here for 11 months, Michael. Woo, Michael M. And we got 1 month away to our 1-year anniversary, Michael. Thanks for being a member for a full year. How amazing. Glocky says, this is nothing but a political stunt. Everyone knows well that the New York bar is full of Democrats who will break any law, rules, or ethics if it means getting Trump and his supporters. If they were serious, the House would open investigations into every Democrat DA and AG and get every one of their records and embarrass the crap out of them by releasing their emails and their financial statements. But Republicans are cowards. Show Bizzle says, in what alternate reality is this even remotely okay? In the leftosphere, yeah, they have a lot of strange behaviors there. Strange behaviors. Hey, Knox says, whenever you express concern for Tishy's Bents, I am so amused, Robert. Like, does that woman ever do real work? No. Honestly, I'd like to know how often she goes on cruises. I'd like to know. I don't know, she doesn't have a special counsel that she could be funneling $1 million to, but I'm just curious about what her cruise schedule is. I bet it's pretty, or whatever the analog is of that, is probably pretty high. Maybe she joined, Fannie, who knows. But yeah, she sat on that bench for weeks, and didn't move. Ugh. They're going to have to replace that thing. Savdi says, listening to this show has increased my appreciation and admiration for our Constitution so much. Mission accomplished, okay? That's why we love the Constitution. Thank you for your detailed and clear explanations. It is an incredible document that codifies, it's basically like a discovery and an invention all mixed into one. It's incredible. So thank you, Savdi. That's a huge compliment. Hopefully, we can spread that around to more people in this country. Show Bizzle says, as frustrating as it is to sit back day after day watching the corruption unfold, I look forward to your show because you have a funny, dry wit that makes me smile multiple times. Keep it up, Rob. Appreciate you. Thank you, Show Bizzle. Yeah, I mean, look, it is a little depressing and kind of deflating to see our corrupt government being so dang corrupt all the time. But I like to stay positive by remembering that as they fail, we become more free, right? It's like if your prison guards, if the people who are imprisoning you, if they fail, that's a good thing. We're going to be more free, right? We're going to be more free to exit the prison. And that's what's happening with our federal government right now. It's self-immolation. We get to watch it. It's sad that it's our government, but our government is not America, okay? America and the Constitution is something that is integrated into the American people and the American way of life, and our useless government right now is just failing. And, that's going to make us, I think, more free in the long term. But it's going to be messy until we get there. Chris is next, says, thank you, sir. All the work you do is appreciated. Thank you very much, Chris. Or it's appropriated. That's cool, too. You can appropriate whatever you want, share it around, appropriate it with your friends and families. Very good stuff. Thank you, Chris. Brad is here. What's up, Brad? Brad Smart is bringing in 10 membos. Oh, my goodness. Brad, thank you for this. Bringing in Scott G. Tia Tay's coming in. John Doodle's in the house. Heather F. Margaret S. Sweet Tat's here. Heavy G. Dennis S. Albert W. And Rusty B. All coming in courtesy of Brad Smart in the house. Brad, thank you for bringing in 10 new membos into our community. Let's see. What did I do here? We've also got coming in Barb's Loves Alaska. Hey, Barb's became a monthly supporter over on Rumble. You can become a member on Rumble too. Very nice to have you there, Barb's. Thanks for joining up over on the Rumbles. Geg says, okay, I know there was a lot of political action going on, but there was also a 9-0 SCOTUS ruling against the Biden administration stance that it is immune from consumer lawsuits against government agencies. Seems like a good ruling for the people's rights. Maybe you can take a look and opine on it. Here's the ruling. Thank you for that, Geg. Yeah, that's not jumping out at me at which one you're talking about, but thank you, Geg, for that. Hopefully you're having a beautiful day there in the UK. Hold My Halo says, best live yet. Love the Membo gifts. Amazing. Hold My Halo. Thanks for being a Membo and for sending in a super chat. Glad you're a member and we're grateful to have you. We have morning streams. We have Saturday streams. And if you want to join the after party, grab the Telegram link in the community tab section. Scroll down and you'll find it. Tree Climber says, everyone has a fanny. Most keep theirs covered. That's true. That's appropriate. Fanny may have gotten hers tattooed. We don't know. They got a tattoo when they were, I think, in Aruba for $78. And I want to know what that is. We got B. Thorne. Whoa. Oh, my goodness. Okay. B. Thorne says, okay, Rob, I'm in northern Colorado, and I'm embarrassed we have crazy eyes in our control of our election. I know. She's seriously crazy. Any ideas for us to have a voice with our Democrat governor? Man, it's a good question, B. Thorne. I know it's kind of the cliche answer, but man, you gotta rally as many local people around you and get them to the polls as you can. And I know it's going to be a little awkward. Like I know, to talk to people and get them to go to the polls with you and just remind, hey, are you voting today? And how are you voting, right? Let's talk about what your decision is going to be. I'm going to be extremely obnoxious to everybody in my entire life in Arizona to get out to the polls, and here too. I can't even wait for it. We're going to get out the vote so stinking hard this year. I'm going to throw my back out. Okay. So we got to do that, right? B Thorne, like we got to really level it up. So that's the plan. We got B Thorne. Thank you. We got Steven says, do the Fannie hearing with good logic so I don't have to go back and forth. Oh man. So he's doing it too. Well, that's good. You're going to get two separate takes on it. Good Logic is going to do a great stream, no doubt. Maybe we'll go check in on him while we're streaming. We got Tony Hay says, you give me knowledge to call out my brainwashed liberal friends and family. Thank you, Rob. Well, thank you, Tony Hay, man. That's another huge compliment. We want to try to make it fun here, but make it actionable, right? So, to provide some knowledge that you can do something with, and in a way that is digestible and maybe memeable, right? Repeat this, and because that's what they're doing, right? We are in an informational battle, like no doubt. Alex Jones is dead right about this. Info war is happening right now, and it is extremely powerful, right? We're going against weaponized informational efforts. It's, social media, mainstream media. We have like mass formation events with like COVID and stuff, like reprogram half the country. It's wild. So thank you, Tony. Thanks for being here and supporting us, man. I mean, we couldn't do it without you. So we're glad that, there could be a nice relationship here. Appreciate that. We got some new ones in the house. What's up, Alan Harkin? Alan, what a nice thing. Says, I run out of good things to say about you. I do continue to appreciate your way of making people like me understand the ununderstandable. Well, Alan, thanks for that, man. And I know you've been a member over on Rumble for a long time and very generous over the years. So thank you so much for saying that. I appreciate you right back. And as I said, this is it's a very mutual thing. I wouldn't have the capability to do it or the energy to do it if it wasn't for, the conversations we have. You guys really inspire me. I learned a ton from you, and we're just warming up. So thank you, Alan. We got Zulu in the house, modding down the fort for us and bringing in new donos. Thank you, Zulu. Bringing in Solemn Peace, bringing in Randall W, Steve D, Rachel K, 4 Shizzles coming in. The End, Mr. Twister, Drew D, No Mandates, and Not a Fed is here, and Mighty Almighty Snoopy is coming in, courtesy of our friend Zulu in the house. We got Senevies on locals. Thank you, Senevies. Says, if Trump won but wasn't allowed to take office, I think that there would be a big conflict. Hopefully not, but I don't see how that would be avoided. Yeah. If they do it again a second time, it's going to be as very peaceful. It's going to be very peaceful. The feds are going to cause something to happen though, but I'm sure it's going to be very peaceful. Zutral says, great show, Rob. I think the part with Hamilton ×3 in the Federalist Papers would make a good short vid from Zutral. That is a good comment as well. All right, let's say hello to our friends on X. We missed our friends on X yesterday because our computer was tripping out. Who is joining us over on the X platform on the day before we wrap it up and go over to locals? We got 28 viewers on X. Oh my goodness. What's up, Danny McWilliams? We got Mainers in the house. Silicon Valley Reject B Torn is here. B Torn says, I wonder, could a president recuse himself, let the VP take the lead on asking questions? For example, Kamala was a border czar. Could she be charged if she broke the laws involving her work on it? Well, I think the Supreme Court's going to tell us a lot about, presidential immunity. Does the vice president have immunity? Good question. Night Watchman says, hey, super happy we have a guy like this. Thank you, Night, for saying that. Danny's here. Danny was sick. James Pepper says, thank you to Tony Hayes for the memo. Danny says, been sick the last week. There are some things that prepping can't control. Hopefully you're feeling better, Danny. Being sick is never any fun. Silicon Valley Reject. We got Croatian Cowboy. Tushy, can we switch Tishy to Tushy? We could. Yeah, I mean, we kind of were going with Tushy a little bit there for a while. The biggest Tish. We were calling her the biggest Tish in New York. Remember that? So, there's a lot of options there. There's no doubt. Endless names of options. And Zutral, thank you for sending that one in, Zutral. Hamilton ×3 would make a good short video. Yeah, that was a good one. Maybe we can share that one around. Okay, my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We're going to debrief and hang out for a bit. So come and join us. Website, robertgovea.com, links in the description below, has all of the PDFs over there. And watcherlodge.com is our sovereignty and self-development community. We got a lot of cool stuff cooking. Go over there, sign up for Political Zen Wellness with our friend Jason Campbell. He's awesome. If you're saying to yourself, I don't need any Zen wellness, you're the exact candidate for this. Okay, so come and join us. That's exactly how I felt. So come and join us. Go to watcherlodge.com. Register, click that you're going. We're doing it on Zoom. We're going to do breathing. We're going to do some mindfulness stuff. It's going to be awesome. So come and check that out. Before we wrap it up, want to say thank you to our mods and our meme smiths who mod down the fort for us and keep things nice and orderly, including our amazing mods, Vienticus Prime, our friend K Bean in the house, our friend Just Cause, Playin' Hooky, Ronnie Cole, Zulu's here, Beyond Geo, of course, Zach Nichols, John Allen, Janek 909, Dog Digger, and Donut Mind Meme, all in the house. Our meme smiths are Sleepy Dog Lee, Geegum Geegum, Nathan, N810 over on the locals. But that, my friends, is it for us on the day. I think we had one more dono come in from Sandy. What's up, Sandy? What did I just do with this? Sandy in the house. There it is. Sandy says, double jeopardy for Donald J. Trump Senate trial has a strange set of facts. Judge Roberts has a constitutional duty to preside over it, but he refused because Trump was a private citizen. The government still held the trial using many of the rules of criminal procedure. Roberts knows he couldn't sit on that case, yet it happened. Roberts' opinion of double jeopardy is already known on the basis of that fact. And Debbie says, Rob, I put a comment in. Oh, thank you, Debbie. All right, we're going to hit those comments right now on our after party. So Debbie will be right there. Thank you for that reminder. We'll get over there. But my friends, that is it for us on the day. Tomorrow's going to be Wednesday. We're going to have a lot to get to. More Trump updates, more ballot removal stuff, I'm sure, somewhere. We're going to find out what's going on, and we're going to bring it here. And we hope that you join us so that together, and we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Make it a beautiful evening. Sleep very well. See you right back here tomorrow. Bye-bye.